You are listening to a Garris Horn Insight podcast. The opinions here are not legal advice, but listen anyway. Today, we have a special edition of Garris Horn Insights. We are talking today about the Townstone case. There was a recent ruling we think is of interest to people, our clients, and others out there. So we thought we would do a quick recording on what happened and where it goes from here. So with us, we have, of course, partner Rich Horn, who's been very intimate and very involved in this case. There was a recent ruling on the Townstone case. We find that interesting because, well, we've been involved with the firm has been involved with the Townstone case for a very long time. Why don't you kind of tell us where we were before and what's happening?
Thanks, Ray, for arranging for this podcast. I think this is going to be beneficial to our listeners to hear our perspective on the Townstone Financial case. I'm sure they've been seeing people post about it on social media and have been seeing news reports about it because the Seventh Circuit just issued its ruling in the case yesterday. July 11th. We're doing this podcast on July 12th, Friday, the day after. And I think it's important for our listeners to hear our perspective because we've been involved in the case since the very first days back in 2017 when Townstone Financial got their CID from the CFPB beginning the investigation of the company for redlining. And we helped the company respond to that CID, represented them through the investigation, and then through the time when the Bureau filed this lawsuit, where we worked on the motion to dismiss at the district court level. And this case was historical because it was the first time a non-depository mortgage company had been sued for redlining by the federal government, at least under this modern day redlining theory, as the government likes to call it. Previously, all of the government enforcement actions by DOJ, by CFPB for this modern day redlining theory had been against banks, but this was the first one against a mortgage company. And this was a tiny mortgage company, one office. At any one point in time during the facts in the government's complaint, the company only had about 6 loan officers. So when this lawsuit by the CFPB was filed, it really shook the industry, especially the IMB side of the industry, to its core because they realized, oh wow, we could be hit with a lawsuit. This is something that we had before been able to just say, oh, this is not something that we really have to worry about. That's a banking thing under the Community Reinvestment Act, but now it's real. Most banks have settled any allegations of redlining in the past. So this legal theory, which is really, it's not in the statute. I mean, and I'm just going to talk to the Equal Credit Opportunity Act, which is the only statute that the CFPB, which is the agency that sued Townstone, has authority under. The statute doesn't say anything about this redlining theory. The statute just says creditors can't discriminate against applicants. And applicants in the statute is defined as people who've applied for credit. This modern day redlining theory, and our firm has done webinars on this in the past, and you can reach out if you want to hear some of those or want to talk about this issue more. But the modern day redlining theory has nothing to do with applicants. It's entirely based on a regulatory provision that says creditors are prohibited from discouraging prospective applicants from applying. So a prospective applicant is very different from an applicant, somebody who's actually applied. There's no definition of what a prospective applicant is, but the way the CFPB is interpreting it in this enforcement action and in others it has had in the past, essentially, anybody in the country or in the market area that they're basing their complaint on, who may or may not apply for a loan. There's no specific like prospective applicant that they identify that said, hey, this person walked through the door and asked for a loan and you told them, hey, go away. That's not the way these complaints are read. It's just all about where the lender is marketing, their demographics of their loan officer staff, and in the Townstone case, this is why another reason the case has gotten a lot of attention. Townstone advertised on the radio, and the CFPB pulled out about 5 minutes of radio advertising over the hundreds of hours of broadcasting they did over 4 years to say those five little short snippets of shows that were about 5 minutes long were discouraging to African American applicants in Chicago. So this theory has nothing to do with applicants. But like I said in the past, banks had always settled these cases in part because a lot of the times it would be a joint action between either the federal banking agency and DOJ or CFPB and DOJ and fighting two federal regulators, as well as making things more difficult for yourself when dealing with your prudential federal regulator for straight bank reg issues like whether you can engage in a certain activity or not. That it can become problematic if you're fighting the government in a discrimination lawsuit. So a lot of banks just settle these. And so this legal theory, which is not from the statute, it's entirely regulatory, has never been litigated in court. Townstone decided to fight this both from a statutory authority standpoint, but also for First Amendment reasons. The owner of Townstone is a firm believer in the First Amendment and everybody's right to free speech, no matter what you're saying on the radio, whether the CFPB likes it or not. You should have the right to say it, right? And so Townstone decided to defend itself in court, and I think also because the owner of Townstone is not somebody who has ever actively or ever discriminated in any way against any applicant, anybody who's called up the company, or any prospective applicant, as the CFPB is interpreting it, as anybody in the world. The owner of Townstone has actually lived on the south side of Chicago, and a lot of these statements we're talking about, his experience living in Chicago and dealing with high crime rate in Chicago, or historically talking about how there were not a lot of grocery stores. It was a food desert, as a lot of sociologists call that problem, or a lot of even commentators call that problem. So a lot of these statements amounted to social commentary and political speech, and that should be protected by the First Amendment. So Townsend decided to fight this, and we filed a motion to dismiss. The motion to dismiss had essentially two main parts to it. One was the statutory authority arguments that I talked about. Basically, the fact that the statute just says applicants. I mean, and that's the entire statute. There's nothing in the statute about prospective applicants at all. And and then the other side of it were First Amendment arguments that this essentially amounts to viewpoint discrimination by the CFPB. If Townstone was out there saying things that the CFPB agreed with, or at least the staff at the CFPB agreed with. For example, if he had been out there saying Black Lives Matter, then CFPB probably wouldn't have sued him. That's viewpoint discrimination. So we filed that motion to dismiss in the district court. The district court took a long time to rule on it. And so discovery started, and it's not a cheap proposition to fight these cases, especially if discovery started. You're spending a lot of money on discovery, and so we were able to luckily find and have joined the case the Pacific Legal Foundation, which is a nonprofit civil rights law firm that joined the case at the district court level. And so because they were doing the case pro bono, that really took a lot of the financial burden off of the client. And so we were able to continue the fight. Luckily, the district court held a hearing, and then about 2 years after we initially filed the motion to dismiss, the district court ruled for Townstone for based on the statutory authority arguments that essentially ECOA, the plain language of ECOA is limited to applicants. that CFPB can't expand the boundaries of the statute based on the general rulemaking authority in the statute beyond applicants. And so it found, because it found on the statutory authority arguments, it didn't reach the First Amendment arguments, and it dismissed the CFPB's case with prejudice. CFPB appealed to the Seventh Circuit. We filed briefs in the Seventh Circuit last summer. There was a hearing, I think it was in December of last year, at the Seventh Circuit. And the way the oral arguments went, I think a lot of people who heard them thought that Townstone had a very good chance of winning in the Seventh Circuit as well. And the arguments are very similar. Statutory authority, First Amendment. Unfortunately, and like I said, unexpectedly, the Seventh Circuit issued its ruling yesterday in favor of the CFPB, reversing the district court's decision and remanding back to the district court. The Seventh Circuit's opinion was entirely based on the statutory authority arguments. It didn't reach the merits of the case. It didn't talk about First Amendment at all. It left that for the district court if we raise the First Amendment arguments again in the district court. It didn't even reach some of the other more nuanced statutory authority arguments that we had raised. And actually, I shouldn't describe them as statutory authority. I should describe more as regulatory authority, because we had other arguments that were based on the CFPB's interpretation of their own regulation, how that was unreasonable to interpret prospective applicants so broadly to mean anybody in the entire world, even if they hadn't even thought about applying for a loan.
I'm sorry, I mean to cut in, but it's like that's what I think is interesting. But I see how we transitioned. But that was the part, I guess, that really wasn't overly addressed, and particularly in the Seventh Circuit, they only focused again on the ECOA issue, correct?
At a motion to dismiss stage, you have to take all of the allegations in the complaint as fact. So that's what the courts have been doing. But the way the CFPB is describing the show in their complaint is really inaccurate. It was a show sponsored by Townstone, but it was really,
Right, right,
it
exactly,
was intended
exactly,
to.
right.
It
That's
wasn't
what I
like
meant.
an infomercial. Buy this product. Buy this product. Buy this product. No, it was intended to be free information to the public about mortgage and making them available for people to call in and ask questions. They would have guests on the show, like local real estate brokers talking about hot areas. They would have discussions, but had nothing to do with mortgages or real estate at all. They'd have discussions about how, like, the discussion for one of the statements that the CFPB called out was a discussion about how the owner of Townstone had lived in Chicago in the 90s, and it was a food desert. He was basically encouraging young listeners especially, to buy property in quote unquote transitional neighborhoods, because although it was bad back then, the neighborhood got better over time. And he was just talking about his experiences living there back then when it was a food desert, and how everybody who lived in Chicago had to go to this one grocery store. And that's what, actually, when you listen to the statement, he's just talking about his own experiences and historically what people used to call the grocery store. Now, these things aren't like an infomercial. Say, hey, only $9.95. Buy
Correct.
this product. This is just kind of relaying one's own extemporaneously, really relaying one's experience about living in Chicago in the 90s, and you so for the government to say you can't do that on the radio, that really raises First Amendment problems, and the characterization of these radio shows is really inaccurate, because it wasn't like that infomercial style that I mentioned. I should talk a little bit about the Seventh Circuit opinion itself. I think it's a very short opinion. Unfortunately, it's very disappointing. It doesn't grapple or even engage with their arguments that we made at all. One of the things the CFPB, for example, one of the things the CFPB was relying on for this regulatory provision is this grant of general rulemaking authority in ECOA. Is a provision in ECOA that says the Bureau can issue rules that further the purpose of the statute and prevent evasion of the statute. And the Bureau was essentially saying, under that, we can essentially issue any rule we want. Whatever the statute says, it doesn't matter. We can do whatever we think furthers the purpose of the statute or prevents evasion of it. We briefed the court that actually there's Supreme Court precedent in a case called Townstone Financial that it says actually that type of general rulemaking authority, and this is a quote from that Supreme Court case, well, a close quote, I'll paraphrase it, doesn't allow agencies to police outside the boundaries of the statute, which is essentially what this regulation is doing. The boundaries of the statute are applicants, and the regulation is saying we can go after activity with respect to prospective applicants. This Supreme Court precedent we raised in our brief, but the Seventh Circuit didn't even mention it in their opinion. Basically, what the Seventh Circuit did was it's a very short opinion, about 15 pages with their small margins. If you pull it up on like a Westlaw or Lexis, I think it's going to be like five pages in a Word document or something. But half of it is talking about the facts in the case, and the other half they basically say the ECOA has this grant of general rulemaking authority. Of course, the CFPB can issue this rule under it. Also, one of the other arguments that the CFPB made was that because there's a referral provision that says agencies have to refer to DOJ if there's discrimination or discouragement in violation of the statute, that the word discouragement being in the statute means that Congress, of course, understood that this regulation that goes beyond the boundaries of the statute is okay.
What I'm saying is
that's what the that's what the Seventh Circuit based its opinion on. It did not grapple with any of the arguments we made. There's another string of cases that has to deal with a provision in Reg B that tried to expand applicant to include guarantors, and multiple circuits, including the Seventh Circuit, said the regulation can't go that far. And these two situations are one and the same. The agency saw something that wasn't covered by ECOA and tried to expand the scope of ECOA to include it. For the string of guarantor cases, it was expanding ECOA to cover guarantors, which are not applicants. And in Townstone, it's expanding ECOA to include prospective applicants. And we have multiple circuits, including a case that was actually in the Seventh Circuit, where the Seventh Circuit said, we don't think the statute can be stretched that far in the regulation to include guarantors, a case called Moran Foods. And this Seventh Circuit opinion just kind of brushes that off to the side and says, well, that's different. That's guarantors, not prospective applicants.
Also, ECOA doesn't mention prospective applicants anywhere. The general prohibition against discrimination only refers to discrimination against applicants, but the court said it can't constrain, quote unquote, artificially ECOA to a single provision, and then said an analysis of ECOA as a whole makes, quote unquote, clear that it prohibits discouragement against prospective applicants. That in spite of ECOA never mentioning prospective applicants at all, and only entirely throughout ECOA mentioning applicants. But you keep in mind that what the court also said was, hey, we're going to weigh really strongly the referral provision that says agencies have to refer discouragement in violation of the statute. And the statute doesn't even mention prospective applicants. So that provision is saying that you have to refer discouragement of applicants. It's the only thing the statute refers to. So on one hand, it's saying it can't constrain ECOA to a single provision, but put a whole lot of weight on that single referral provision, which doesn't even say what the court thinks it says.
So this is it's an opinion that's very light on analysis, unfortunately. But I think that it's something that
Correct.
that happens. You can get a bad result even though you're on the right side of the law.
The idea is ECOA says applicants. It doesn't go beyond applicants. So when you're discouraging, it means discouragement of applicants. That's what it means. The Seventh Circuit took a look at it and really kind of, I'm going to say, stretched it in the context of Regulation B to say, well, they have authority. So two things happened. One, it's very broad authority under ECOA to do regulations, so the CFPB can do this. This was one of the law. It sounds like the legal logic. Coupled with this idea of discouragement was somewhere referenced elsewhere in the statute, and then that was then kind of pulled together as then they must have been prospective applicants as well for discouragement. But that's what's happened, right? So basically, they look at the regulation, they pull it and stretch it so that the CFPB could have the authority to apply their opinions of what Reg B should be. I'm sorry, what ECOA should be via Reg B, and then also using the idea of, well, discouragement was referenced in ECOA, so it must have been the applicants. That must be the prospective applicants, not just the applicants, but any person out there that could be possibly an applicant, and that's what they meant. That's what Seventh Circuit basically said, correct?
Yes.
So the question now is, and you bring it up, and we're all waiting, bated breath. So the fight's not over. Tell me about that.
Yeah, we're evaluating our appeal options. We can request rehearing en banc in the Seventh Circuit, so all the judges in the Seventh Circuit would hear the case, or filing a petition for cert in the Supreme Court. There's a lot that goes into that analysis of which route we go, so I'm not going to say more about that, but we obviously think the Seventh Circuit got it wrong. There's very little analysis in this opinion. They didn't even address Supreme Court precedent that's on point. That Dementia Financial case is talking about basically the exact same general rulemaking authority that's in ECOA. And then the Seventh Circuit didn't address that. The Seventh Circuit just kind of pushed the other circuit court opinions to the side, including its own. And
Right.
also, one thing the Seventh Circuit could have done is address the First Amendment issues. One thing that was in the recent cases that overturned Chevron, Loper, Bright, and Relentless, and the Supreme Court said, look, the courts have to interpret delegations of rulemaking authority to see what the boundaries of them are, and essentially whether they are within constitutional limits. Here, like we talked about, this rule, the Reg B provision, that's based on and the enforcement of it in this case that's based on language, but primarily the rule facially is about the viewpoint of statements that are made. It violates the First Amendment. If you want to learn more about this case, reach out. Happy to talk about it. If you want to talk about redlining or fair lending compliance in general, happy to talk about that as well. Stay tuned. The fight's not over.